1 minute. Okay. Welcome to West Virginia University College of Law. I am Matt Totolo, the Associate Dean for Faculty. Today we celebrate Constitution Day 2025. Constitution Day was established in 2004 through legislation sponsored by West Virginia's own Senator Robert Byrd. The law required that every educational institution receiving federal funds hold an educational program each year on September 17th, the anniversary of the signing of the Constitution in 1787, designed to promote a better understanding of the Constitution and our system of government. Faculty panel today is entitled Universities, Academic Freedom, and the Constitution. And the First Amendment to the United States Constitution provides that Congress shall make no law abridging the freedom of speech or of the press, a principle that has become a cornerstone for democratic discourse in the United States. Academic freedom flows from these same commitments, ideally ensuring that colleges and universities remain spaces where ideas can be tested, challenged, and refined without fear of censorship or government-enforced orthodoxy. At a moment when institutions of higher education find themselves at the center of national debates about academic freedom and freedom of expression, today's conversation could not be more timely. This year, our faculty panel will explore the contours of academic freedom in today's universities. Our moderator, John Taylor, is Jackson Kelly Professor of Law at WVU College of Law. He teaches constitutional law, religion, and law, among other courses. Jerry Edwards recently joined the WVU College of Law as an associate professor. Until recently, he was an attorney with the ACLU of Florida, where he worked on combating educational censorship and promoting bail reform. He teaches courses in constitutional law, civil rights, and freedom of speech. Finally, John Estep is a visiting associate professor at the WVU College of Law, and until recently, a member of Milbank LLP in Washington, D.C. He teaches constitutional law, professional responsibility, and torts. Please join me in welcoming our panelists.
Okay, and when we're done, Matt will have the mic and we'll hand it around for questions. So thank you, Matt. So as the old guy, I wanted to take the opportunity to just frame what we're going to do a little bit more. And I'm really delighted to be doing this with Jerry and John. I've been getting to know them, John for a bit longer than Jerry, but they're both really great, really smart, really personable, really knowledgeable, and I've learned a lot from them, and I'm sure you have too. Okay, so my framing would be this. Our Constitution has been through a lot in the last 236 years. Popular and legal understandings of the Constitution have changed over time, sometimes in ways the framers would likely have found surprising. But that makes sense because the framers would likely have found most features of modern life surprising and probably unimaginable. That is not a criticism. We're all human beings. We're embedded in history, and we have no idea what 200 years from now is going to look like, assuming the human race makes it that far. They were no different, right? But a relatively brief document that is extraordinarily difficult to amend because of the high bar in Article 5, that it has lasted as long and served us as well as it has is a remarkable achievement, even if the uniquely audacious American project of creating and maintaining a fully free and equal society based on the ideals in the Declaration of Independence remains incomplete. This year's Constitution Day comes at a remarkable time in the history of our constitutional order. Nearly every day of the second Trump administration brings some new claim of presidential power, often followed by the immediate exercise of the claimed power. And while presidential power has been growing steadily across presidents of both parties for many decades, and President Trump is certainly not the first president to push the envelope in this regard, the scope and boldness of unilateral presidential action over the last 8 months dwarfs anything we have seen before, including during the first Trump administration. Many scholars, most notably and famously the Yale professor Bruce Ackerman, have suggested that the late 1930s was a, quote, constitutional moment in which the Roosevelt administration articulated and the court and the public ultimately accepted a different vision of the constitutional order in response to the extraordinary challenges posed by the Great Depression. And I suppose the most charitable way one could characterize the present moment is that President Trump, like President Roosevelt, is attempting another constitutional revolution of a sort, one that will reshape the balance of power within the federal government and also allow the president substantial power to leverage the federal government to reshape behavior in the private sector as well. The framers would have expected Congress to check this kind of presidential expansionism, but that hasn't worked very well for a while, and we can all see that it is not working now. So whether this attempted revolution ultimately succeeds in reshaping our constitutional order depends to some extent on whether courts will accept it, but it depends to a greater extent on whether we, the people, accept it. The people, after all, did vote for this, and it was all laid out in Project 2025, whether people were aware of the contents of that document or not. And I suppose the framers would say it was always an illusion to think that our constitutional order would sustain itself without the continued active participation of the people through free elections, free and informed discussion and debate, and it must be said in this moment, complete renunciation and unconditional condemnation of political violence in whatever form it may take. On this last point, one of my favorite political philosophers, Gordon Sumner, who you will know as Sting, put it this way in a 1988 in a beautiful song called Fragile. If you don't know it, check it out. I will spare you my Sting impression and simply read the words so you can understand them. Perhaps this final act was meant to clinch a lifetime's argument that nothing comes from violence and nothing ever could. For all those born beneath an angry star, lest we forget how fragile we are. The album is called Nothing Like the Sun. It was made before most of you were born. It's awesome. Check it out if you don't know it. So there's a lot to talk about on Constitution Day. Given that we have an hour and 15 minutes, and given that some of us are notoriously long-winded, we need some way to narrow our focus. And since the bulk of our audience are members of a university community and we are professors, we thought we would look at some of the constitutional issues around various efforts to reshape the way universities operate. The division of labor will be, first, Professor Estep is going to talk about the general idea of academic freedom, its constitutional roots, particularly as it relates to classroom speech. Second, Professor Edwards is going to talk about cuts to federal university funding. He's written an interesting and really useful and helpful paper on this topic, And this hits close to home for me in multiple ways. Our land use clinic, directed by the amazing Kat Garvey, who is down here, has over the years been the recipient of many competitive federal grants supporting their work because they are very, very good at what they do. Now, in the last few months, a good many of those grants have been impacted, and as a result, we're going to lose 4 of our clinic staff next Friday and possibly another person in January. That is a terrible loss to our community and the institution. It is a loss to our students. And maybe most of all, it is a loss to the state of West Virginia because the Land Use Clinic has done an extraordinary amount of work around the state that will not be done if there are not land use clinic people there to do it. So that is a big deal. On a more personal note, those of you in my class know that my older son Ben defended his PhD dissertation in oceanography last Friday, and he studies the effect of climate change on the oceans, particularly the southern ocean surrounding Antarctica. You can connect the dots of why that might be a problem in the present moment. So in any event, the funding issue is a big deal to me. And then lastly, I'm going to talk about probably the most frequently invoked ground for cutting university funding, the claim that prominent private universities, including Harvard and Columbia, violated Title VI of the Civil Rights Act of 1964 by failing to do enough to prevent the harassment of Jewish students by pro-Palestinian students. Okay, with that, I will turn it over to John.
All right, thank you, Professor Taylor, and thank you, everyone, for being here. I think this is an important topic. For my part, I'm going to speak a bit about the Trump administration's kind of campaign since starting the second term to root out, both within the federal government and outside of the federal government, DEI, diversity, equity, inclusion initiatives and programs, and in particular, how that has impacted and may impact in the future institutions of higher learning with respect to academic freedom. Professor Totolo, I think, gave a good description of what academic freedom is, and I think that the importance of it in many ways is self-evident. So I'm not going to spend a lot of time on that, but I am going to discuss academic freedom in the context of constitutional doctrine, and I think through that, some of the importance will come out. So I want to get right into it. I'm going to start by talking about some of the specific actions that the Trump administration has taken, and then I'm going to move into a couple of what I view are egregious impacts on colleges and universities. I'll then go into and talk a little bit about constitutional academic freedom as a constitutional concept, as a component part of the First Amendment, and what the Supreme Court has had to say about that. And then finally, we'll discuss how the government speech doctrine potentially impacts academic freedom and confronts academic freedom in a way that needs to be squared going forward if we're going to protect academic freedom to the maximum extent we possibly can. Certainly during the campaign, there were comments about attempting to end DEI, but the first real action of the administration happened in January of 2025. There was an executive order, 14173, which did a number of things, but for our purposes, the most important of which is that it sought to end all, quote, discriminatory and illegal preferences based on DEI frameworks. It also directed the Department of Justice to come up with a plan to seek to end DEI in the private sphere as well. And it revoked certain Biden-era executive orders with respect to affirmative action and anti-discrimination that the Trump administration apparently viewed as antithetical to its anti-DEI approach. Notably, that executive order did not define what DEI was, what illegal DEI was, and you'll see that this is a theme with respect to the administration's actions, and it can be difficult to define because diversity, equity, and inclusion can mean different things in different settings, whether you're talking about a diversity-related course or you're talking about a DEI initiative or program at a university, or you're talking about DEI with respect to enrollment. It can mean different things, but query whether the administration's failure to define it in any kind of concrete way is intentional, and whether it has resulted and potentially exacerbates kind of the chilling effect that flows from that. Following that executive order, there was a Dear Colleague letter that was issued by the Secretary of the Department of Education, Linda McMahon of World Wrestling Entertainment fame. That letter said a number of things. It was focused primarily on the Title VI of the Civil Rights Act of 1965, which Professor Taylor is going to speak a bit about. But that one of the things that letter did is made certain accusations and criticized DEI and encouraged universities and colleges to end those programs. Following those actions in President Trump's first joint address to Congress after taking office, he said this: "We have ended the tyranny of the so-called diversity, equity, and inclusion policies all across the entire federal government, the private sector, and the military, and our country will be woke no longer." I don't agree with him that at that point in time, all diversity, equity, and inclusion programs had been eliminated across the board in all aspects of our society, but certainly the intent is and was there then. A couple of short days later, and perhaps drawing inspiration from President Trump's remarks, the then acting U.S. Attorney for the District of Columbia, named Ed Martin, issued what many of you have probably seen this letter because it became public, a letter to Georgetown University's law school. I'll note that it is a private law school, and in that letter, Ed Martin, based on whistleblower information concerning DEI efforts that were happening in DEI initiatives within Georgetown Law, sent the letter, accused Georgetown of not eliminating DEI, and as I said, it's a private institution as a reminder, not eliminating DEI across the board, and threatened not to hire any students from DEI in his office in the District of Columbia or from any other law school that was continuing to use DEI. In a response to that, the next day or a couple of days later, by the dean at Georgetown Law, William Traynor, which I thought was spot on, he said this, among other things: "The First Amendment guarantees that the government cannot direct what Georgetown and its faculty teach and how to teach it. The Supreme Court has continually affirmed that among the freedoms central to a university's First Amendment rights are its abilities to determine on academic grounds who may teach, what to teach, and how to teach. This is a bedrock principle of constitutional law." Beyond those specific actions, there have been others, but those are three main ones. I want to talk about a couple of impacts in higher education that have flowed from those actions. One notable one is in February of this year, following the executive order, the University of North Carolina system, which includes UNC Chapel Hill and a number of other universities, announced that none of their universities could continue to require, quote, diversity-related courses as part of requirements for degree programs. Okay? And in making this announcement, the general counsel of that system made clear, one, this was being done in response to the executive order from the Trump administration. Two, that he had no idea what illegal DEI really meant because the executive order had not specified it and was unable to provide any guidance to the universities that were part of the system, but nonetheless, out of a concern for the Trump administration's potential efforts to reduce funding and take other steps that might impact the universities in a really detrimental way, the system was making this decision. Without that guidance, you can imagine this has created problems. I'll give you one example. The University of North Carolina in Asheville interpreted the memo as ending a mandate that students take two, quote, diversity-intensive courses. Now, these diversity-intensive courses included a number of courses of which students could choose. One of them was titled Philosophy and Sex and Gender, but there were other courses that were included on the list, including Introduction to the Hebrew Bible and History of Mathematics. One can understand the dilemma here. After this decision, the North Carolina Conference of American Association of University Professors called it an overt attempt at thought control and educational malpractice, a comment with which I happen to agree. One other instance where there has been a negative impact in higher education, and this one hits closer to home, is the recent resignation of the long-term president at the University of Virginia, Jim Ryan. Jim Ryan was on the faculty at the law school there when I did my law training at the University of Virginia, and he was resigned under pressure from the Trump administration, specifically the Department of Justice, based on allegations that notwithstanding the Trump administration mandates to remove DEI from all aspects of the university, that had not been done entirely and completely to the administration's satisfaction. There were threats of withholding funding to the university, and rather than subject the university to those potential consequences, he resigned. I will note that beyond these examples, there have been countless examples of universities across the country removing references to DEI and diversity from their websites. Faculty members have scrubbed references to diversity from their research interests. It is harder to tell what chilling effect maybe has occurred in the classroom, but it is not unreasonable to think, I think, particularly among untenured faculty, that the Trump administration's efforts in these regards could have an impact and a chilling effect in the classroom. I now want to turn to academic freedom briefly as a constitutional doctrine which first emerged in the 1950s in response to McCarthyism and the Red Scare. There are two principal cases in this area. The first was Sweezy versus New Hampshire in 1957, which arose out of a situation where a Marxist professor had given a guest lecture at the University of New Hampshire. The Attorney General in New Hampshire had subpoenaed him to answer questions. He had refused, and there was a contempt order that was given. The Supreme Court overturned that contempt order on the basis of the First Amendment, and particularly academic freedom. In that plurality opinion written by Justice Warren, there was a really good quote that I think really crystallizes the reason why academic freedom is important. And so if you'll bear with me, I'd like to read it. Justice Warren wrote, "The essentiality of freedom in the community of American universities is almost self-evident. No one should underestimate the vital role in a democracy that is played by those who guide and train our youth. To impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. No field of education is so thoroughly comprehended by man that new discoveries cannot yet be made. Particularly that is true in the social sciences where few, if any, principles are accepted as absolutes. Scholarship cannot flourish in an atmosphere of suspicion and distrust. Teachers and students must always remain free to inquire, to study, and to evaluate, to gain new maturity and understanding. Otherwise, our civilization will stagnate and die." The other principal case in this area is Keishian v. Board of Regents. It's a 1967 case. It involved the merger of what was then a private institution, the University of Buffalo, with the State University of New York system. After that merger, the state of New York wanted to require everyone on the faculty to sign off on loyalty oaths, essentially said that they were not communist. A number of the faculty refused, and on that basis were terminated, and the Supreme Court overturned that on the basis that of academic freedom, noting that academic freedom is a special, quote, special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. After those two cases, the exact contours of academic freedom are not entirely clear. The Supreme Court has made clear in subsequent cases that it does apply at an institutional level. Academic institutions are free to choose their courses and who they fire and hire on the basis of academic freedom. What is a little less clear is to the extent to which individual faculty members within the classroom possess that academic freedom. The circuit courts have addressed that issue in a variety of ways that has really muddled this, but we're waiting for the Supreme Court to weigh in. Let me say a bit about the government speech doctrine and why it presents a potential problem here. So the government speech doctrine is quite simple, and it is this. When the government itself is the speaker, it may express its own views and is not subject to First Amendment content or viewpoint neutral requirements. So unlike when it acts in a regulatory role, restricting or facilitating private speech, if the government is the speaker, it can say what it wants, essentially, when it wants, and the reason behind that rule is that the government must be able to promote its programs, espouse its policies, and control what its spokespeople are saying. This doctrine is applicable in basically three contexts. One, government-hosted speech, where a private speaker is speaking on government-owned or controlled property. Government-subsidized speech, which Professor Edwards is going to speak about, where the government restricts speech as a condition of financing or subsidizing a program. And then the third setting and context, which has the greatest implication with respect to academic freedom of professors in public institutions in the classroom, public employee speech. Right? And there are two tests that have developed in this area primarily, starting in 1968 with the Pickering test. The way that courts would assess whether a public employee had freedom of speech rights, notwithstanding they were public employees, it could potentially be considered a government speaker, was to assess first whether the content of the speech was one that was of public concern, and then two, if it was, there would be a balancing test weighing the employee's right to speak against the government's interest in providing efficient public services that it employs through its employees. In 2006, the court in the Garcetti v. Ceballos case made a big change to this doctrine and held that when public employees make statements pursuant to their official duties, they are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from discipline. One can imagine how this could potentially decimate academic freedom in the classroom, particularly in public institutions where professors who are teaching students are acting in their capacity as public employees. And if they are deemed to be the alter ego of the government, this could potentially harm academic freedom and the freedom of professors to teach how they want and to share views in the classroom to their students, even unpopular ones. And so there are two real ways where this government speech doctrine conflicts potentially with academic freedom. One is at the institutional level. If you can imagine the institution, if a public institution is considered to be the alter ego of the government, then that could potentially take away and strip away from the institution the ability to choose who it hires, who it fires, what it teaches, and how it teaches things to students. On the other hand, in the classroom, as I just mentioned, if professors at public institutions are public employees and they are therefore speaking as the government, if they're speaking in the scope of their position as a public employee, that could be a real problem. It's unclear what test would apply to that. It could be Garcetti, which would be a real problem. It could be Pickering, which would require a balancing test, but obviously, given the nature of the balancing test, could leave quite a bit of room for mischief. And it's worth noting in all of this that state governments across the country have been doing some sneaky things to try to avoid challenges based on academic freedom. One of those things is they have been expanding their boards of visitors or their boards of governors and placing on them certain people that are politically aligned with the legislature, so that then you are rather than arguing that there is an alter ego between the institution and the government, you are aligning the institution with the government as such that if the institution is making the decision, there might not be an argument that academic freedom is being imperiled. And the other is, and that Florida is a really good example of this, states are starting to target curricular programs and courses as opposed to regulating what can be said specifically in the classroom. And by doing that, they've tried to avoid some of the challenges based on academic freedom. To conclude, I'll just say the administration's determination to root out DEI in all forms certainly has had negative impacts on public institutions so far and private colleges and universities, and I expect that it will continue to do so, and it shows no signs of stopping. And in light of that, I would say it is of fundamental importance that the court square the concept of academic freedom with government speech doctrine in a way that maximally protects the ability of universities to teach courses they want and teachers of those courses to teach what they want in the way they want without government interference. Professor Edwards has also written on this and has some really good ideas about the tests potentially that the court would apply. I don't know that he's planning to speak on that, but I'm sure he would be willing to talk about it in response to a question. Hint, hint. And in the end, I wholeheartedly agree with Justice Warren that teachers and students must always remain free to inquire, to study, and to evaluate to gain new maturity and understanding. Otherwise, our civilization will stagnate and die. We should take steps now to reinforce those protections before it is too late. All right, Professor Edwards, thank you.
All right. Thank you to Professor Estep for that great introduction. And unfortunately, no, I will not be able to talk about that scholarship during this specific talk just because we don't have 2 hours and I don't want to bore you. Thank you for the opportunity to speak here today. I am very honored to be able to speak on Constitution Day. As an American, the Constitution is what unites us, and so this is a really important thing to honor. I'm Jerry Edwards. I am a new associate professor of law here at WVU Law. So what I'm going to focus on are the constitutional implications of the conditions the Trump administration has placed on academic research grants. Now, I'm going to preface my talk here by acknowledging that this is not wholly unprecedented. So, federal government, you don't need to strip our funding. The President Obama has used the threat of stripping federal funding from universities to get universities to accept his preferred process for investigating and adjudicating Title IX claims for sexual misconduct. He also did that with hostile education environment claims under Title IX. And civil libertarians and civil rights organizations did argue that President Obama's policy in this area was violative of due process and violative of the First Amendment. And so in that vein, President Trump is in some ways taking what has already happened and kind of building on it. What's different here is that the Trump administration, instead of targeting specific policies it wants universities to adopt, it's kind of trying to impose their ideological perspective on what universities should be. And so that is where they have expanded upon classic ways of doing this. And granted, President Obama was not the one who originated this either. There are a lot of old Supreme Court cases from 40, 50 years ago before I was born that are on this topic, like South Dakota v. Dole, which talks about conditioning federal highway funds on states raising the drinking age to 21. So again, this is not new, but the way it's being wielded is somewhat novel. So before I jump in here, I should talk a little bit about what President Trump has done. So John mentioned an executive order, and operationalizing that executive order, these agencies have essentially said, we're not going to give federal research funding if you are studying or discussing certain ideas. And those ideas include diversity, equity, inclusion, DEI. If you are promoting diversity, equity, inclusion, we're not giving you money. And in fact, if you've already been awarded money by, say, the Biden administration, we're revoking that money. We also have gender ideology, is what phrasing they've used, and that deals with transgender people, or the idea that gender is not binary, that sex is not binary. And then finally is environmental justice, and that might be where we're getting hit hard in our clinics, although that's debatable. Certainly, I don't know that our clinics would say that all of our work is environmental justice, but that's kind of the problem with the executive orders, is that they're worded in a very broad way, but they don't define these terms, and so it's kind of left up to the discretion of officials, and it doesn't really give fair warning. So those are the three big topics that they've been cracking down on, that they've been terminating billions of dollars in research funds and then refusing to award new funds to that type of research. It doesn't have to be that your research is necessarily focused on it. If you even discuss it, you might be punished. So you might be asking yourself right now, what are grants? I mean, that's a fair question to ask. I didn't really know much about grants until fairly recently. So grants are, in their essence, a funder provides a pot of money and says, I want you to use this money for this purpose. And so in the academic research context, a funder may say, and that funder may be the federal government, maybe state government, maybe local government, maybe a nonprofit organization, may even be a private business or a corporation. It will say, let's say I want to provide $5 million for a cure for cancer, and I want the best proposal to get this $5 million, and we're going to study cancer with it. So then what happens is that the funder will solicit proposals, and it will award that $5 million to the best proposals. That's an example of what a grant is. And so there are two types of grants you should be familiar with: non-competitive grants and competitive grants. The grant I just discussed is a competitive grant. And what that means is the government or whoever is funding it, they're going to have to look at what ideas are coming in, and they're going to choose the best idea. Non-competitive grants are different. They're not looking at who has the best idea. Instead, you make a pot of money available, and anybody who is eligible can receive that money until the money runs out. So an example, and I assume it works out this way at WVU, I might be wrong, but this is how it worked when I was in college and law school back in the day, is that student organizations will receive a certain amount of money from the student fees that are paid out. And if you're a student organization, all you need to do is request that money, you receive it, and then everybody can get money until the pot of money goes out. They don't look at the events you're holding. They don't look at how good of a student organization you are. As long as you were eligible, you get the money. They're not choosing what the best ideas are. They're just giving money away. So as I noted earlier, academic research generally involves competitive grants. Why is what's happening now significant? Well, the federal government is the biggest funder of academic research. So they hold a very powerful stick here to beat universities and academics with if they run afoul of the federal government. Hundreds of billions of dollars that they can take away. Now, that is very significant. And so what happens is it chills people. It chills universities, it chills academics from researching in the areas that the federal government does not want them to research in. And so what we're having here is the federal government essentially saying, if you're researching DEI, if you're researching environmental justice, if you're researching gender ideology, broadly construed, you need to stop and you need to figure out something else you can research because we're not giving you any more money. The money spigot is off. And I think that is damaging. And it's damaging because many of our most significant discoveries as a society have come from academic research. The internet, smartphones, many of the components that are in a smartphone came from academic research. Even something like Ozempic, the miracle weight loss drug, it was created in part based off of things learned in a study in the 80s about Gila monster venom, lizard venom. And so many of our great breakthroughs just come from people being curious about things. They don't always make sense at the time, but they often lead to incredible discoveries. Penicillin was discovered by accident. Radioactivity was discovered by accident. So it's very hard for the government to say that this area of inquiry has no worth, that we should never come anywhere close to it. They might be killing the next great breakthrough, and that is the danger of what we're seeing. So I've talked a bit about the importance of grants here. Let's talk about First Amendment law, because there are a few different concepts that are relevant here. And unfortunately, there's a lot of uncertainty in this area because the Supreme Court has laid out rules over the years, and some of these rules arguably conflict, and they've never really been utilized in this sort of fashion. And so it's hard to tell how they all fit together. I'm going to focus on three specific things, and Professor Estep has already covered two of them pretty well, add a little bit, but he's done a great job of discussing them. Those being unconstitutional conditions, government speech, and academic freedom. So, unconstitutional conditions. What are unconstitutional conditions? In a very simple sense, it means that the government cannot do indirectly what it is not allowed to do directly. That's very abstract, so what does that mean in practice? What it means in practice is when the government controls a valuable benefit or privilege, it cannot condition access to that benefit or privilege on you giving up a constitutional right. And so let's use an example. If the government offers a tax break worth thousands of dollars, it cannot condition receipt of that tax break on you agreeing not to criticize the president. That is unconstitutional because the government cannot directly tell you you're not allowed to criticize the president or else we'll fine you. And so it can't say in order to get thousands of dollars in benefits that you're not allowed to criticize the president. That violates your First Amendment rights. And so in the context of academic research, how would that apply? Well, if the government is saying you're not allowed to discuss or study these certain ideas, or else we'll impose financial penalties by refusing to give you money, period, that is an unconstitutional condition. Now, that all sounds very simple. Okay, this is an unconstitutional condition, so that's it. We're done. The Trump administration is violating the Constitution. Unfortunately, it's not quite that easy because this second concept, government speech, also arguably applies here. And the leading case in this area of government subsidized speech, as John mentioned, is Rust v. Sullivan. And in Rust, the court held that the government can choose what it is funding to the omission of other things. And so it can draw lines around what it wants to fund and say, I'm not funding this, but I am funding that. And so to use an example to make it crystal clear, the government can say that I'm going to fund cancer research, but I'm not going to fund research on heart disease. And if I'm a person who studies heart disease and I apply for that grant and they reject me on that basis, I can't sue under the First Amendment and say, oh, that's not fair that you're not giving me money for heart disease under this cancer allocation. The government's allowed to do that. It's allowed to omit heart disease and say we're studying cancer with this money. And so that does create this question of how these things fit together. And over the years, there have been some funding cases that have tried to kind of strike a balance here and figure out how this works with unconstitutional conditions in government speech. And the rules that have come out of it apply differently depending on whether we have a competitive grant or a non-competitive grant, which is why I distinguished the two earlier. So with a non-competitive grant, because the government is not looking at the substance of the idea, it's not picking the best idea, separating the wheat from the chaff, the court has said that when you impose viewpoint discrimination, it is unconstitutional. And the leading case here is a case called Rosenberger v. University of Virginia. And there, the University of Virginia said, we're going to give money to student publications, but you're not allowed to speak from a religious perspective. And the Supreme Court said, if you're going to give this money to any student publication, you can't impose this punishment on publications who are speaking from a religious perspective. So you may be asking, if you're not super familiar with First Amendment law, what is viewpoint discrimination? At its core, it means the government cannot choose a side in the argument. So if the state of West Virginia passes a law saying that you're not allowed to argue that apples are the best fruit, that is an example of viewpoint discrimination. I could still argue apples are the worst fruit. I could still argue oranges are the best fruit, but I cannot argue that apples are the best fruit. And so in that case, the government has chosen a side in the argument, and that almost always violates the First Amendment. In fact, Judge Grant on the 11th Circuit called viewpoint discrimination the First Amendment's greatest sin. It is almost always unconstitutional. And here we do have viewpoint discrimination. The Trump administration is saying you can't discuss diversity, equity, inclusion in a positive light. You can't discuss gender ideology in a positive light. You can't discuss environmental justice in a positive light. Now, competitive grants are different. Competitive grants, the court has said, need to be treated differently because the government has to be able to separate the best ideas from the not best ideas, maybe the worst ideas, maybe just good ideas. And because of that, you can't have a strict viewpoint discrimination rule because they do have to discriminate on viewpoint to a degree. I mean, if you're focused on cancer cures, someone may have a great idea for a cancer cure and someone may even have a better idea, and you're picking the better idea. So you have to have some ability to do that. So what the Supreme Court has basically said in this context is as long as you're not using funding coercively to try to chase ideas you disagree with from the marketplace of ideas or suppress ideas you disagree with government, we're going to allow you to do that. Finally, we have this concept of academic freedom. And again, John has given a great explanation of what that is. So I will just simply add that academic freedom, the constitutional doctrine, does protect academic research. What is not clear is how it applies here. Courts have generally closely scrutinized things that infringe on academic freedom because of the contribution it makes to the marketplace of ideas and our democratic self-governance. But it's never applied the test in this sort of fashion. And so we don't know how it will actually be involved in these cases. Now, the Trump administration has argued that what it's doing is constitutional, and it's relied on two cases. The one I mentioned, Russ v. Sullivan, we are simply defining what we're going to fund and what we're not going to fund, in a case called USAID v. Open Society International. And in that case, the court held that when the government leverages funding from a grant program to try to reach speech outside of the program, that is unconstitutional. And so if the federal government said, West Virginia University, I will give you $5 million in cancer funds, but you have to release a statement saying the president is the greatest man to ever live, that would be unconstitutional. That would violate the First Amendment under USAID. And what the Trump administration has essentially argued is that USAID supplanted these previous First Amendment cases like Rosenberger, and so the only restriction now is you can't leverage funding to reach speech outside the grant program. The federal district courts have disagreed, and I think they are correct. They have instead said, no, that's not right. All these rules have to fit together, and so USAID applies where you're leveraging funding to reach speech outside the program, but we should apply Rosenberger when you're reaching speech inside the grant program, and NEA v. Finley, the competitive grants case. And here, the district courts have concluded that the Trump administration, by wielding all this money to go after these disfavored ideas, is acting in a coercive manner to try to suppress ideas they consider dangerous and try to drive them from the marketplace of ideas. That is what the district courts have held overwhelmingly. The Supreme Court has not yet weighed in. It has created some procedural roadblocks using the Tucker Act, arguing that these are contract-based claims and they should be brought in different court. And the problem there is if one follows those procedural roadblocks, it forces universities and academics to have to wait years to get the money that is being denied to them now, ostensibly for a violation of the First Amendment. And so the problem with that is, when you can't get this money for years, and it's a lot of money, what are people going to do? They're not going to take that risk. They're just going to stay away from this area. They're not going to talk about DEI. They're not going to talk about gender ideology. They're not going to talk about environmental justice. They're just going to do what needs to be done to stay within the bounds of what the Trump administration is saying. So in that vein, justice delayed is justice denied. So on the merits, though, the Supreme Court, it appears we have a 4-4 split. And it looks like Justice Barrett is going to be the swing vote. She has not tipped her hand which way she will go on this issue. I do think there's a plausible argument under Rust. The Trump administration is just saying what it will and won't fund. Ultimately, I don't think that's the best argument. But if the Supreme Court does accept that, I think they would argue that it's, President Trump won the 2024 election, democratic process. He should be able to choose what he does and doesn't fund with federal funding dollars. Again, I see the appeal of that argument, even if I disagree with it. So let me conclude here by simply saying I think it's really important at a time like this when free speech rights are under threat to say that whether or not you agree with a specific point of view, you can oppose DEI. You can oppose, in your view, what is racist speech. We all have to defend the right to have unpopular beliefs, the right to speak beliefs that people disagree with, and we need to do so in a nonviolent manner. This is a really important time where we have to learn to tolerate speech we disagree with. And so I will quote Justice Felix Frankfurter here from one of the cases that Professor Estep discussed, Sweezy v. New Hampshire, an attack on academic freedom during the McCarthy era. And he said, "This kind of evil grows by what it is allowed to feed on." And that is indeed what we are facing now as a society. Intolerance for speech we disagree with is an evil, and it is growing by what it is allowed to feed on. And so no matter where you fall on the political or ideological spectrum, I think we all have to come together to defend the First Amendment and to defend free speech. Thank you.
Get my timer out so I don't go crazy here. We're going to run short. Hold on a second. 1 hour and 45 minutes. That ought to do it. Okay. All right. These guys are good, are they not? I enjoyed listening to them. I'm hard act to follow. Okay, so Professor Edwards has just talked about funding cuts. We've all heard something about the administration's battles with Columbia and Harvard. With Harvard in particular, the Trump administration canceled more than $2 billion, that is billion with a B, dollars of research grants to Harvard unless Harvard agreed to an unprecedented level of government control over its academic operations. And the administration has said that there is no point in Harvard applying for any future grants because it will not get any. President Trump has also tweeted that he may consider revoking Harvard's status as a tax-exempt institution, right? Now, some might draw the inference that what is going on here is both simple and obviously unlawful. That inference would be that President Trump regards universities, particularly prestigious private universities like Harvard and Columbia, as political enemies, and he is using the vast leverage at his disposal to bring them to heel. That's an easy inference to draw because that's been openly said by President Vance, Vice President Vance, among others. In between the time we started planning this and today, Harvard has won a sweeping victory in the Federal District Court of Massachusetts, relying on some of the things that John and Jerry talked about, for example, the doctrine of unconstitutional conditions, basically saying that the simple story is essentially right. That decision will be appealed. There's a complicated jurisdictional question that may cause trouble, but it seems pretty obviously right to me on First Amendment grounds. Part of the point is that basically the retaliation and playing tough with Harvard was in part because Harvard fought back. And both John and Jerry have talked about leverage and the enormous leverage that is carried by federal support of research dollars. And what often happens is the kind of thing John described with UNC, right? You've got a vague rule. You've got so much leverage that the university doesn't want to run afoul of that rule. And so not only do you not violate the rule, you stay clear of violating the rule, self-censor yourself even further. For those of you who read Tim Snyder, that's what he calls obeying in advance. So that's the way things normally go. Harvard did not do that. In any event, my topic today is the sort of official story of why Harvard lost funding. The DEI stuff plays a small role as well, but the lead idea has been the notion that Harvard violated Title VI of the Civil Rights Act of 1964 by basically failing to do enough to protect Jewish students from allegedly anti-Semitic harassment by pro-Palestinian students in conjunction with protests over the Israel-Gaza war. I've read quite a lot about this in the last few weeks, and this happens when you read a lot. You only realize how much more there is that you should have read that you didn't have time for. So this is a deeply fraught topic. There's a lot of stuff I don't know. So I approach this with trepidation, and I will keep my aims fairly modest. So what I want to do is the following. First of all, I want to provide some background about what Title VI is and how it works. I teach a course in education law where I talk about things like this, but I haven't gotten to teach it in a long time, so most of you probably don't know a lot about that. Second, I want to explain a less than fully settled constitutional issue in the background of the Title VI issue, and I would put the most important constitutional question this way. Can students engaging in what would be considered protected speech under the First Amendment be considered as a factor in whether or not the university has allowed a hostile environment to exist, right? That, I think, is a difficult and unsettled question. Third, I want to acknowledge that while figuring out how to respond to post-October 7th protests, the universities were in a very difficult spot with a lot of no-win options, and I think we need to understand that. At the same time, I do think that the universities probably dropped the ball in some ways, and though I think that the administration's attacks have been wildly overbroad, I think there are some things that probably were Title VI violations and that other administrations might have gone after as well. I think one thing that's going to happen as a result of all this, and we're seeing it already, is that universities are trying to avoid being put in these situations, and the way they've done that is to adopt more and more restrictions on campus speech. This is happening all across the country. That is concerning. And I suspect that the killing of Charlie Kirk, among its many other evils, is going to contribute to that dynamic as well. So, Jerry talked about, well, let's stand up for free speech. Let's stand up for free speech on campus, I would say. So fourth, whatever the degree to which one thinks universities botch their handling of the protests, and however one thinks that the tensions between protected speech and hostile environment harassment law ought to be resolved, there is no reasonable argument that Title VI authorizes the Trump administration's actions in canceling huge amounts of federal funding to Harvard. What the administration has done has never been done under Title VI, and it hasn't been done in this way because there are actually rules about what you have to do to pull funding, and the administration has not followed any of those rules. That has been reported a little bit in the press, but not nearly enough. So those are my 4 big points. Let me see where I am. Okay, could be worse. Okay. First topic. What is Title VI of the Civil Rights Act of 1964, and how does it work? Okay, so Title VI prohibits discrimination on the basis of race, color, or national origin in programs or activities that receive federal financial assistance. It is a parallel law to the later enacted, but more famous Title IX of the Education Amendments Act of 1972, which does the same thing for discrimination because of sex. Jerry talked about South Dakota versus Dole. Both these laws are exercises of Congress's spending power, right, where the government is offering the carrot of funding in order to induce private institutions to sort of support and apply anti-discrimination norms, right, thing that happens a lot. Federal financial support includes grants of the sort that Jerry and John have referenced, but it also, very, very importantly, has been understood to include taking federal student loans, which I bet lots and lots of you have, right? And once that was decided, basically it becomes the case that essentially every educational institution in the country takes federal money in one way or another, so they're basically all bound by Title VI. Further, statutory law that corrected an earlier, well, I guess that's a dangerous word, that changed an earlier Supreme Court decision makes it clear that if any piece of the university takes federal money, the entire university is bound to comply with these anti-discrimination norms. Title VI can be enforced through private actions for damages, but it most prominently is enforced by the Department of Education's Office of Civil Rights, which is usually called OCR. Given that the Department of Education is being dismantled without Congress's involvement, which I would have thought was unconstitutional, but we shall see, I guess, if the merits are ever reached. They're probably going to transfer this to the Justice Department. I don't know if they've done that yet, but in any event, I'll talk about OCR. Okay, so federal courts have long recognized that Title VI and Title IX can be violated by the existence of a hostile environment based on a protected characteristic, which again under Title VI would be race, color, or national origin. And a hostile environment can exist under this body of law, even if the actors who are the source of the hostility are not employees of the university, but rather students of the university, right? So this is usually called peer-to-peer harassment. Now, it is important to explain, right, that even if students are the ones who are sort of making life difficult for other students on the basis of their protected characteristics, students cannot themselves violate Title VI, right? A student can't violate it, only institutions can. So basically, the rule is the school or university can violate Title VI on a hostile environment harassment theory only if 3 things are true. First of all, there've got to be a hostile environment based on one of the protected characteristics. Second, the school or the university must know about the harassing environment, right? Generally, they actually know, but there's a thing called constructive knowledge, which basically means you're negligent if you didn't know. So in the event, they've got to know about it. And third, they've got to fail to take adequate steps to remedy the condition once they know about it, right? So the basic idea is schools violate Title VI on a peer-to-peer harassment theory if they know about the harassment and they don't do enough to stop it, right? That's basically the theory, A lot turns, of course, on what counts as a hostile environment, and the bar is generally thought to be pretty high. OCR says the standard is a hostile environment involves unwelcome conduct based on race, color, or national origin that, based on the totality of the circumstances, is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from a school's education program or activity. Most of the work in that definition in the litigation turns on severe and pervasive, right? The Supreme Court has said these kinds of rules should not be understood as creating a civility code, right? You've really got to have something that is significant enough that we can say that thing or those incidents added together made it impossible for the student to take full advantage of the educational experience they are there to receive, right? And in the case law, that's typically been a pretty high bar. Okay. All right, last point about Title VI. You may be wondering how anti-Semitism can violate Title VI because religion is not one of the protected categories in Title VI. But since 2004, both Republican and Democratic administrations have taken the position that the protections of Title VI extend to students who are or are perceived to be, because of their shared ancestry or ethnic characteristics, to be Jewish, Israeli, Muslim, Arab, Sikh, and so forth. So under this long-standing interpretation, nearly all Jews will be protected from harassment by Title VI, even though religion is not a protected category. Okay, what's been the normal enforcement pattern in the past, right? I think my experience has been in reading cases has been that the private damages actions are often hard to win, right? But OCR sort of has an easier time winning in the sense that they've got a ton of leverage. And Jerry talked about this. OCR tends to have enough power that telling schools what they should do will generally get schools to comply. Jerry referenced the Obama administration's sexual assault rules, which some people thought were very aggressive, and basically this was the thing where the administration went around. They used something called a Dear Colleague letter that John referenced. What that means is, Dear colleague, I write to inform you of some rules we may be enforcing that you might want to pay attention to. Those letters don't go through notice and comment rulemaking for those in administrative law. They are not hard law, but because they are indications of how the administration is going to view certain actions, they are kind of taken as soft law. And soft law, when it is coupled with leverage over enormous amounts of money that universities cannot live without, functions as hard law. And thus, whether the universities liked it or not, when the Obama administration said this is what your rules about sexual assault have to be, the university said, done, right? And then that became a controversial thing. So playing hardball here, as Jerry also said, is not new. But generally speaking, in the past, what you did in playing hardball was you tried to change behavior. The goal was never, we're going to take away the university's money and kill its research. And indeed, there might be some obscure exception, but I don't know of any case prior to this administration where Title VI was actually used to pull the university's money. That just was not the goal. So that's a big change between kind of the past and now. Okay, so transitioning quickly to my second topic. Oh my. All right, that's what I say when I look at the clock. Sorry, okay. Let me say a little bit about the free speech issue, right? Scholars have long recognized that there is a theoretical tension, right, between the idea that speech should be free, that the government should not be able to punish it, and the idea that harassment is unlawful and can be punished, right? Because often harassment involves some speech, right? How do we deal with that? The Supreme Court has never kind of said a whole lot to deal with this, but some case law has developed, and a lot of articles have been written about it. And a simple example would be something like this. Harassment is going to tend to be speech that is derogatory based on a protected characteristic, and it is very much targeted at a specific individual. So to take the kind of example OCR gives, if a Jewish student is staying in a dorm at a university and has like a whiteboard on his door, and once or maybe lots of times he leaves and he comes back and somebody's taken a marker and they've drawn like swastikas all over the board and said something like dirty Zionist or whatever, everybody's going to agree that is harassment, right? And not protected by free speech. How much of that you need for it to be severe and pervasive might be debatable, but nobody's going to say that's protected. Nobody's going to say that if a student were disciplined for that, it would be a First Amendment problem. On the other hand, speech that is not directed to particular individuals is normally thought to be speech protected by the First Amendment, even if it is very upsetting to students, seems rude, ill-advised, unfair, whatever. So consider the example that everybody talks about now, the chant "From the river to the sea, Palestine will be free." Now, God knows I am no expert on this, right? But I can say that from the basis of my reading that I think the following things are true. I think it is true that many Jewish students sincerely hear that is basically calling for the destruction of Israel, and the destruction of Israel is going to mean the killing of a lot of Jews. And so they would characterize it as a call for genocide, and I can understand why they see it that way. On the other hand, many Palestinian students do not understand it that way. They see it as something like a call for sort of more just treatments of Palestinians in the future, the end of what they see as an apartheid state in Israel, that kind of thing. It also seems likely to me that many people chant such slogans because, well, you showed up at the protest because you think too many people have been killed in Gaza, and that's what everybody's saying, so why not? Right? But in any event, however you interpret it, most law professors seem to think, and I agree, that this looks like protected speech. Indeed, under our free speech tradition, right, even if you interpret it in the most negative way as a kind of genocidal call, the reality is if you think it's hate speech is protected under American law. You may disagree, but that's the law. Attorney General Bondi apparently doesn't know that, but that is in fact the law. If you think that this is like a call for violence, what we call a call for violence is legally is incitement. And incitement only loses First Amendment protection if basically you intended to get people to break the law or here to commit violence, right? And you said what you said in a context where it was likely that people would react with violence and they would do it imminently, meaning really, really soon. That's the Brandenburg test, which I've got to teach for the first time tomorrow. So in any event, this is probably protected speech, right? So you can understand at the same time why Jewish students might be made uncomfortable by this, might feel not welcome in an educational environment where such things are said a lot. And that is the source of the tension here, right? How do we reconcile protected speech and harassment law? So I would say there are three questions here. And oh my word, okay. Let me just do this real. Okay. Well, the big question is this: how do we deal with protected speech and harassment law? Right? Can that count as part of a hostile environment or not? That's unsettled. I wish I could say more about it. Last 2 points I will make extremely briefly. First of all, I said I think everybody's got to agree the university's probably dropped the ball on some stuff and probably allowed things to happen that they should have cracked down on. I think the clearest example of this is a lot of the cases that have been filed and have been discussed involve the idea that sometimes protesters or students sympathetic to the Palestinian cause basically blocked the ability of Jewish students to get into certain buildings or to get access to places. That is a bread and butter clear Title VI violation, right? If you can't get into a building that is on the campus, that absolutely is a material interference with your right to enjoy the benefits of the education, and that's just going to be a Title VI violation. I think that's pretty clear, and that's cut and dried. The last thing I'll say is just my preview, the same thing I said in the preview, which is if you're going to strip funding, which again, no administration ever actually wants to do before this one, you have to basically do things that involve following formal legal rules and processes, right? You got to have hearings. You got to make findings. You got to say, here's what we've got. The university's got to respond. You got to give them a chance to fix it. And then and only after the university won't do what you want, you have to wait a while, and then you could pull the funding. And were any of those steps taken here? No, they were not. The Trump administration just basically said, we think Harvard is engaged in anti-Semitism. They should have done more to protect Jewish students. We're pulling $2.2 billion deal with at Harvard. And whatever you think about anything else, the law just does not allow you to do that. And if there's one thing I'd like you to remember about the Title VI justification for all of this, it's just like there is no reasonable argument to the contrary. I think the press has done a poor job of making that point because it's just absolutely clear. Okay, that's it. Thank you guys for listening. So we're sort of out of time, but if you don't have class, I'm happy to direct for all of us to take some questions.
We have another 2.5 hours.
Exactly.
But we do have a few minutes if people want to ask questions. We have a microphone. The reason we use this is because we're recording this, so we'd like everybody else to be able to hear it. So if you have a question, let me know. Maybe we can come up and here over here and grab that microphone. If you have questions. If not, okay then. It was all crystal clear. It was a very simple area of the law. There could be no questions. There could be no follow-ups. Okay, well then we'll have to thank our speaker.